Morning and welcome to the Standing Policy Committee on Property and Development for this February 9th of 2026. My name is Councillor Evan Duncan. I'll be chairing today's meeting. I'm joined by Councillors Santos and Dobson, members of our public service and our senior committee clerk, Ms. Cowan. We do have 5 items on our appeals hearing agenda today. I'd like to begin by acknowledging that we're on Treaty 1 territory, the national homeland of the Red River Métis, and that our drinking water comes from Shoal Lake 41st Nation in Treaty 3 territory.
In accordance with the City of Winnipeg Charter and the Development Procedures Bylaw, the process the committee will follow is the appellant will be heard first, followed by those in support of the appeal. Next, those registered in opposition are heard, followed by those registered for information. Finally, the appellant may return to speak in rebuttal to comments made. However, no new information is permitted. Please note that when your name is called, it is your opportunity to speak. However, you are not obligated to do so. Item 1 is an appeal under the vacant building bylaw number 79 of 2010 at 197 Euclid Avenue. If you'd like a brief overview from the public service,
Please.
Good morning, Chair and Councillors. I'm Corey Burgess. I'm the Acting Administrative Coordinator for Bylaw Enforcement Operations for Community Services Licensing and Bylaw Enforcement. I'm joined today by Michael Tran, Bylaw Enforcement Coordinator for the Vacant Buildings Bylaw. I'll be providing a brief overview. Officer Tran is available to provide specific details related to any questions raised. We have some prepared statements and preamble for the record, as well as a quick overview. I will draw your attention to the enforcement summary and photos provided as exhibits. The Vacant Building Bylaw 79/2010 was adopted by Council to regulate the condition of vacant buildings and discourage boardings. The bylaw provides guidelines for property owners to maintain properties. One of the main objectives is for the safety of first responders and for the overall safety and well-being of the community. Important to note that licensing and bylaw enforcement is primarily complaint-based and response to community concerns about a vacant building received through 311 or as referrals from other agencies, such as Winnipeg Fire Department. When a building is determined to be vacant, an information package is sent to the owners identifying the building is deemed to be vacant, subject to the vacant building bylaw. LBE also provides an information brochure on the vacant building bylaws and all associated fees. In accordance with Section 15(2) of the Vacant Building Bylaw, bylaw enforcement officers conduct regular inspections of vacant buildings. At minimum, once per year, officers conduct an interior and exterior inspection of the building to identify the minimum property standards as identified in Schedule A of the bylaw are in compliance. Where officers identify bylaw violations, compliance orders are issued. These orders serve as education on the bylaw regulations and provide the owners information on what needs to be addressed. Specific to this property, 197 Euclid Avenue used to be a church. This location was subject to multiple fires. Records indicate on January 6, 2025, a fire event occurred at the above noted address, known municipally as 197 Euclid, which caused significant damage. Our colleagues in PP&D responded and remain involved in the mitigation of an unsafe structure. Licensing and bylaw enforcement received and responded to community complaints in March and April of 2025. Licensing and bylaw enforcement became involved with the property as a vacant building on or about April 30th, 2025. Licensing and bylaw has issued 7 orders for conditions observed at the property. Change in ownership was noted July 30th of 2025. Previous owner advised us they sold effective May 30th. The appellant being the new owner of the property. Owners have complied and corrected some conditions identified. The department has undertaken remediations. Licensing and bylaw enforcement is aware that PP&D is also involved with the mitigate unsafe condition and obtain permits order. That order provides owners 2 options, repair or demolish. As of February 9th, there remain no permit applications or progress towards compliance for the property. In the absence of work towards compliance with that order, vacant building enforcement is running concurrent and complementary with PP&D enforcement. The appellant was issued a Schedule A order for the following deficiencies: exterior walls, roofs, including fascia boards, soffits, flashing eaves troughs, downspouts, combustible material contained within, and every wall and ceiling in a building shall be maintained in safe condition. The deficiencies were observed and all conditions noted in Schedule, are conditions noted in Schedule A of the Vacant Building Bylaw. The order was therefore served registered mail and complies with charter and bylaw requirements for service. The appellant has indicated an objection to the fees and costs of enforcement. Important to note, no penalties or fees directly associated with this order. There are fees associated with vacant buildings, as the committee is aware. However, at present, the department has issued an order identifying non-compliant items to meet minimum property standards. Application of enforcement tools would follow if no movement towards compliance became evident. Thank you.
Any questions for public service this time?
So just to confirm, what we're here dealing with is under the vacant building bylaw.
Yes.
Okay, and you said there are orders outstanding?
The matter before the committee today is one Schedule A order, which should identify
Okay,
several conditions under the bylaw, which from the photos, I think would become evident that those conditions do exist.
On page 2 of the licensing and bylaw enforcement, they're listed under enforcement summary. So it appears that there are 6 LBE orders issued and 1 LBE fee assessment or assessed, sorry.
One inspection fee invoice has been issued. 6 orders were listed here. 1 was from a previous owner, so not listed on the enforcement summary.
The order was November 28th, 2025, and it looks like compliance is due by February 28th of 2025, so.
when was the last time you visited the site? You said in February?
We were there on February 3rd to confirm the
Okay.
posting of the appeal poster as required for this.
And to date, no permit to demolish or permit to repair has been taken?
We see no evidence of any application for permits, whether those are development or demolition, in the system that we share with PP&D.
Thank you.
Sorry, just one other time, November 28th, 2025, order compliance by, is that supposed to be 2026?
Here on the enforcement summary, sir?
Yeah, it's just stating the schedule order. Schedule A order is November 28th, 2025. Should it be compliance date is February 28th, 2026?
That is correct, sir.
Thank you.
Apologies.
No problem. How I picked that out of all these documents, I'm not sure, but at least I'm reading them, right? Okay, I don't have any other questions at this point in time. Anything else from the committee? Okay, we can move on, Madam Clerk.
Okay, the appellant, Pete Sanderson, did not register to speak at this appeal. Just confirming that no one else in the gallery is looking to speak in support of the appeal. Okay, so
What's the point in putting in an appeal if you can't, if you have to come and fill out more forms to talk? I asked that question to,
are you Pete Sanderson?
yes, I am.
Okay, yeah, the notice issued to you indicates that we ask you to register in advance of the hearing, and it provides instructions on how to do so.
I read the instructions. Contact her, and they did not respond, or they were.
So Mr. Sanderson wishes to speak today.
I was by making a few comments.
We'll need you to fill out a public representation form, and then you can speak. You can fill out the form after you've spoken.
Okay,
If you'd
thank you.
like to come to the chair there.
Sure. Mr. Chairman, I prepared a one pager.
I'll let the clerk handle those. Thank
Do
you.
you have multiple copies?
I do. It's general information. You can read it after. It's not specific to the details provided by our compliance tables.
Have a seat there, sir.
Thanks. Joining me is Malcolm Cook, who is a member of our not-for-profit volunteer group. We have no argument, quite frankly, with the the compliance department and their rather difficult task at times. Just so you know where we're coming from, we are volunteers. We've used our own money to bail the church out of its desperate situation. Our intention has been over the last year that we've been involved in that neighborhood is to assemble properties. We were dealing with, and I'm not sure this council could perhaps provide advice. We were dealing with acquiring 881, 80 to 885 Main Street to assemble sufficient property to build an apartment facility with support spaces for counseling and that type of thing. So rather than working in opposition to each other, it'd be nice if we had a capacity to work together. We've got retired architects, professor architecture, professor interior designer, people that taught nursing and that type of thing, all as volunteers with our group. So the intention again was to work with the community, perhaps and ideally set up a land banking system in the area. We're already working with 2 other land banks on an unofficial basis to assemble land. This was one parcel of a number of parcels that we've been working on, again with our own funds. So we're not denying a task of safety and that type of thing. When I finally got through one of our offices, the compliance stuff, within a couple of days, we ordered a bin, and we not only cleaned up the church site, we cleaned up 881 and the other properties around it. We were at it anyway. We'd bought the equipment. We might as well do it. And the graffiti. So from our viewpoint at that point in time, we thought we'd done our job. The next day, it was over the weekend, I think, the wind was up. Our next door neighbor immediately released, I think it's 183 Euclid. Many people appear from time to time to drop off garbage there. I don't want to whine, but we're trying to do good work and got caught in the system. And I don't think the system has enough flexibility to work with the not-for-profits and make the exceptions that might be appropriate, because once you start bending the rules, you get into other issues. At any rate, we know that we're pretty familiar with the needs of the neighborhood, as are any of the officers that work in that neighborhood. So, quite frankly, I don't want to call in any more volunteers for more money to meet this particular requirement. And if the next door property has been acquired by the city, unless the city is willing to work a deal with us for that property, we'll gladly turn over the piece of property we have. And I brought the key for it, just in case you want to go through the door and not the windows or whatever. So, Malcolm, did you want to make any comments?
Actually, that's not how this forum works.
Oh, I'm sorry.
Yeah, not a problem. You have a few more minutes here if you want to add anything else. The committee is also available to ask you questions, perhaps.
I'm ready for questions.
Okay. Any questions at all?
I guess I'm confused about some of the comments that you're making about, wanting to get something from the city of Winnipeg.
Well,
You're going to give us keys. I'm very confused by that statement.
If
Does this have anything to do with the 197 Euclid property that you own?
197 Euclid is owned by a not-for-profit company.
Okay.
If it no longer has the capacity to develop the rest of the land around it because of changes in title or ownership or control, then we'll gladly gift this property to the city so that it can do some better work with it than we're going to be able to do.
Okay.
Councillor Dobson has a question. We'll come back to
Yeah, I have a question. This particular property is not repairable, is it?
No, it's gotta be torn
So
down.
it's gotta be torn down.
Torn down and removed. We don't know if there's other problems with it with regard to PCBs or other contaminants. I got a rough price from Emery to remove that property, the property next door, and we were in excess of $250,000. So that's completely next door.
Okay, so that's just for demolition.
That's just demolition.
Um, so just remind the committee, what organization do you represent?
Southern Manitoba Urban Property League.
And then the title of 197 Euclid belongs to?
To that entity.
Okay, thank you. So you're here today asking, or sorry, you're not disputing the current assessment by our enforcement branch. What are you hoping to achieve here today?
I was hoping to achieve some understanding with the city, or perhaps not, this isn't the right body for it, to work with not-for-profits that have evidence that they have financial capacity to go forward and develop properties. I used to work for Canada Mortgage at one time, and our intention is to build there ideally with their funding.
Yep. Okay. Okay. We're joined by Mr. Habichuk from Property Planning and Development. I do have a question in regards to the statements made by our appellant here today about turning over the property to the city. Has there been any discussion with the department in regards to 197?
No, not to my knowledge. Our department also has an order against 197 Euclid, in addition to the two properties that front onto Main Street, 881 and 885. Those two properties were hit by fire and are in need of remediation, as well as 197 Euclid. And I'm not aware of any current discussions as far as was suggested yet. I can follow up with the department, with our real estate branch and find that out.
Okay.
To my knowledge, it's not happened yet.
If you guys use an acronym, is it SMUP or do you guys just the full title? Full title, Southern Manitoba Urban Properties, Inc. Are you looking to get rid of this property at 197?
We would like to develop it with the property next door, and somebody told me that the city had acquired it or was in the process of acquiring it. If that's not the case, I can continue to deal with the receiver. The property is in receivership.
Yes.
And its original value was, I don't know, $250,000 or something, city assessed value, to be precise. I believe I could pick it up for cash that we would provide for about $20,000. That pays some of their legal bills and gets them off the hook. But there's no point in us taking it if the city's gonna constantly charge us money as we're trying to develop it into something of value to the community. So we would look.
Yeah, unfortunately, the city, especially the public service, is bound by the bylaws that are put in place by council. So in regards to this appeal on the vacant building bylaw number 79 of 2010 for 197 Euclid, is there a request that you're making to the committee at this point in time for our consideration, other than you don't disagree? I don't want to have the committee rule here today and it not help you one way or the other, or move things along one way or the other. So
I'm prepared to gift this property to the city for $2. And providing everything else is written off.
okay,
Otherwise,
that would be a different forum to have that dealt with, but okay.
well, things could be stayed in the meantime. That might help too. It would allow some discussion with the city lawyer on the issues related.
Any other questions by the committee? No, we'll have an opportunity to ask questions of public service if you need to, and then the appellant would have an opportunity to rebut anything that's said at that point in time. So thank you for your presentation. You're welcome to stay, and of course, rebut anything else you hear from this point till the time that we vote on this matter.
Thank you all.
Thank you.
Malcolm Cook registered in opposition to the appeal, but Malcolm, I assume you're here in support?
What's good been saying,
Yes, okay, so you're
My
in,
idea is that we,
oh, so we'll just need you to step up to
Yeah,
the
sure.
table there.
Thank you, Mom. All right, and we'll just give the clerk a moment here to sort out this piece here. All right, thank you and welcome.
well, my intent was that we purchased a lot and we do an RHI submission with the Accelerator Fund team. Our intent was to buy the whole corner and develop into affordable, safe housing for North Point Douglas. We've been trying to acquire this for some time. We've had zero response from RHI submissions, the city in regards to what potentially could be developed, or even feedback on the capacity of what we can develop on the spot. We develop projects, large scale projects as well in the city. And I myself developed projects with MMF at 190 Disraeli, Frame Mache. That was my RHI submission. So we're not new to development. We can develop, but we just need support. We need guidance. We need feedback. We need transparency with the city, and just a lot of more hands-on, rather than being ghosted and marginalized or set aside because there's no communication from the city on our side to what we can help and assist. We want to develop that whole area. It's been an eyesore for many decades since I've been down that street. I've ate at the Yale 25, 30 years ago. And it's been, this constant NIMBYism from the city council to not do anything in that area. But that's the history of Winnipeg. That's where everybody came from off the train, But now it's so much NIMBYism and attitude from everybody. Even the newer projects are being, shunned on for the people to bring into their area. So this is just a repeat of projects that are trying to be built again and again for people who need them. We connected the community, we talked with the community, and we did hear that they don't want unhoused people in the neighborhood, which is totally fine because you're thinking of safety, you're thinking of family, you're thinking of community. And, I don't blame them for not wanting that. But the idea is that we want to build safe, affordable, clean units, and as much as we can. If I could build 150 units to 200 units on that spot, I would need help from the city and transparency and guidance. I'd rather have that than closed doors and no response. And that's what we're looking for. And if we got to sell the property and give it back to a larger buyer, I regret to do that. I'd rather see it flourish into something for the community that the city can really pat themselves on the back and say, yeah, we're actually going to do something in this neighborhood.
Anything in regards to the appeal here today in regards to the vacant building?
Well, it's a tear down. It's a tear down. There's nothing you can do about it. Like, we've actually bought it initially thinking that we'd buy all the properties so we can demolish them all and build a larger facility. So, considering our submissions, there was zero response from the city. So we're stuck with a donkey.
So you're speaking in regards to, and I'm just trying to zoom in on my map here, 881 Main Street, and then 885, 887, 889.
Yeah.
Okay. So the city does not own those buildings?
I'm not too sure who owns them.
Okay.
Because they kept changing titles. So I'm not too sure. Like, we initially wanted to get them all and build a large project, but we got no feedback on who owns what.
Okay. So I believe Mr. Havlicek here at Property and Development confirmed that the city does not own those. They may be in receivership, but the city does not own those properties.
Not at this time, that's correct.
Okay. So to your point, if the city did own them, then of course we can always look at appropriate properties to potentially work with not-for-profits or for-profit developers to do some type of housing I'm not gonna even comment on what type of housing, but housing in general, we do have a current program that is doing that and looking at properties throughout the city that the city owns.
I'm not aware of that, yeah.
Right, but this is not one of those opportunities. There's a not-for-profit in your folks group there. And then there, I would assume, be some type of other company that owns these other properties and that you guys are addressing here on Main Street. So although I'm agreeing with you that it's a good idea to potentially look at this site, it's not this, that would not be the city leading this. Does that make sense?
Yeah.
Okay.
So
So, in regards to the appeal, are you opposed to the appeal? Are you in favor of the appeal at this point in time in regards to the vacant building?
I'm supposed.
Okay.
I think
Yeah.
there's confusion.
Yeah. So, the appeal is made by, the Southern Manitoba Urban Properties Group. That would be, if you're supporting the appeal, you're saying that, you don't want any sort of, enforcement against 197.
It's a lot of money. Like, it's unnecessary. Like, I'd just waive the fine and help us develop. Because we obviously can't afford a lot of that money. That's
Yeah.
because tomorrow it's going to happen again, or even this summer it's going to happen again. The fence falls down.
Yeah, I hear you. Okay, then we'll note you in support of the appeal. And is there anything else that you'd like to?
One
Councillor
question,
Dawson's question.
I noticed that you said you paid for the site. How much did you pay for it? If I could ask, how much did you pay for 197 use of it?
You paid $1, right?
$2 or $2.
Yeah, okay, so.
Typically, we don't go back and forth from the gallery
Yeah,
here. We'll have an opportunity.
It was burnt out.
Yeah.
And it was initially we had approached them and said our grandeur plan, what was going to be. So they said, yeah, okay, we'll give you for $1, sell it for $1.
Okay,
And initially our intent was to do the grand scale, the big project, but we got zero feedback on our submissions. We did we have access to architects and builders that can actually develop and build on the site if we had support.
but at the end of the day, the property still has to be rectified. It still has to be taken down.
Oh, yeah. It'll be demolished, and I don't know what the soil looks like, but there is a cellar and a lot to be remediated. So
Yeah, but that still has to be done, so. Okay, we're good, thanks.
like the initial development of that portion was to be part of that project. Like, we were going to initially bulldoze it all and remediate the soil and then start the project, but that was going to be part of it.
But again, it still has to be remediated.
Yeah.
Right away versus leaving it for years and years.
Yeah. Yeah.
Regardless of whether a big project comes that you can redevelop, it still has to be taken down.
Yeah.
Okay.
Is there any?
It was a sealed building at one time, but it just got into a fire and then it all went down. Everything went south after that.
Okay.
Aside from this appeal, is there any plans that you're aware of to completely clean up the site? I know you mentioned that some cleanup had already happened. Can you inform the committee about any other type of cleanup or securing of the building at the very least?
Well, obviously it'd be federal money that would initiate that project, and we'd demolish all of the buildings rather than just the 197. We do it all at once together. That was the initial plan, was that we acquire all the lots and we just demolish them all and then build our site right there.
Yeah, but in regards to 197, what, just quickly for the committee, what has been done to clean it up to, at the very least? Like, I'm looking at pictures here of a burnt out building and.
Yeah, other than cleaning up and the around the building and the garbage cleanup and the fence and erection and that, it's pretty much impossible to keep people from climbing the fence and climbing into the actual structure itself, unless we actually have on-site security, and you don't got the monies for that.
Okay. Right. Any other questions at this time? Okay. Thank you very much. Appreciate your time.
So there is no one registered in opposition to the appeal, just confirming no one in the gallery wishes to speak in opposition, and no one for information. So if there are questions for the public service.
Similar question I'll have for you folks is, I'm looking at these pictures from what appears to be December of 2025. Some areas are boarded up, some are not. everything in the interior of the building is still charred remains of whatever. Is that the current state of the building?
Yes, sir.
Yes?
We didn't go inside when we were there on February third, but we believe it is similar condition. We boarded what can be boarded. Our contractor has indicated they're not willing to put a ladder up against some of the walls. And some of the windows do have metal bars already securing them, so you don't see boards on those ones. But multiple city departments remain involved in attending as boards are ripped off and things continue to happen.
And I know this isn't your area either of you guys, but why was this structure not pulled down in the last fire by Winnipeg Fire?
That's an operational call that Winnipeg Fire would make at the scene.
In your assessment, are you able to give the committee any other information? Is it there's still material that's combustible in there that would present a further risk?
We haven't been inside either. Our office hasn't been inside either. It's been fenced and we're waiting for either a demolition application from the current owner or failing that, then we'll engage with other city resources to get it done.
Okay. So in a world where, either the committee enforces this fine or we revoke or we concur in the appeal, the building has to come down. There's we talk about having walls and ceilings and whatnot that are meet code or our standards, but that's not happening here, I would assume, by looking at these images.
We would leave that decision to the owner as to what they choose to do. I'm certainly not the expert on what is structurally capable of being restored to the point where they could turn it back into a church or turn it into something else. But certainly in similar type circumstance, we tend to see these come down as demolitions.
And the total amounts owing by this current organization, Southern Manitoba Urban Properties, is?
On this particular order, there's nothing owing, nothing issued. In terms of what's on tax, I could speculate, but I don't have that actual number in front of me.
So there's no amounts owing. So if
There is an outstanding inspection fee for the vacant building, but that wasn't what was before the committee today.
So if we deny the appeal, what type of financial implications does that have to the organization?
At this point, none. As long as we're seeing them move towards doing something, we'll continue to work with them on that.
Okay.
On the other side of it, if we continue to see nothing, we would at some point apply enforcement tools such as tickets.
Okay. And is this the first you're hearing that they're willing to give up the property to the city?
The first that I've heard of it. It's something I can take back to the real estate branch and see if they have any comment on it outside of this process.
Is there any other questions for the public service? So I'm understanding here that there's no financial implications of this particular order.
At this point.
And if the committee allows the appeal, what happens at that point in time?
It would end enforcement of this order.
Okay. But there will, with almost certainty, be more orders against the building as it's currently unoccupied, not secured.
Remains a vacant building, subject to the conditions of the bylaw.
Okay.
So when we get around to our next annual inspection, we would likely continue our process and reissue another order.
When approximately is that next annual inspection?
Yeah. Approximately in late October, early November.
I don't have any other questions. Any other questions? Turn it back over to the clerk.
Sure. So the appellant, Pete Sanderson, has the opportunity to speak in rebuttal to comments made, but no new information is permitted. So if you wish to rebut the comments that you heard, you have up to 5 minutes to do so. Just a reminder that no new information can be presented.
Thank you.
I appreciate the discussion. I appreciate
Please
the.
sit
Yeah,
down.
grab a seat because the mics pick you up that way. Yeah, no problem. Thank you.
Thank you very much for this opportunity for us to have a hearing on this topic. You've opened up a few new opportunities for us. Now that we know that the property next door to us has not been taken back by the city, I will continue to negotiate with them. But we're going to end up, if we get that property and we're prepared to spend our own money on, I think we got it from $250,000 city assessment down to a purchase price of $20,000. We may be back here doing this again, but at least we'll be working in concert with city officials to try to make something good happen for the city. And if that becomes a gift of the larger properties to the city, we will do it. I would like to mention the cooperation we've had with Corbin Funeral Home, which extends the land base for building a building considerably. They've been very cooperative. They want to work with the city if this proceeds. And that sums it up. Thank you very much for this process.
Okay, thank you. All right,
Obviously, more further dialogue's gonna occur, so I move that the receipt of public representations be concluded.
favor?
Aye.
Aye. Opposed, seeing none, carried.
I move that the appeal be denied in the order of bylaw enforcement, licensing and bylaw enforcement. Oh, what is it? What happened here? And that's the order of the bylaw enforcement officer licensing,
Licensing and bylaw enforcement, community services department.
be confirmed.
Yes, regarding the provisions of the vacant building
Yeah.
for the premises at 197 Euclid be confirmed.
Correct, yeah.
As stated by the clerk, Councillor Santos moves. All in favor? Aye. Opposed, seeing none, that's carried.
I move that the appeal hearing be concluded.
All in favor?
Aye.
Carried unanimously.
Please note that the committee has made a final decision on this matter, which is not subject to further appeal.
Can we just take a brief pause here?
Sure.
And we'll reconvene in 2 minutes.
Okay.
Okay. Welcome back to the Sandy Policy Committee on Property and Development for this February 9th of 2026. We are on item number 2, which is an appeal, and I'll hand that over to the clerk to introduce.
Item 2 is an appeal under the Planning, Development and Building Fees Bylaw number 66 of 2016 at 787 Burbank Street. If you'd like a brief overview from the public service.
Please.
Good morning, councillors, and thank you for this. As mentioned, the civic address here is 787 Burbank Street. The fee in question is a $443 fee for non-compliance for work without permit. 787 Burbank Street is zoned R1, and the subject property was the site of a fire that occurred in the detached garage in June of 2020, and that fire extended to the primary structure, which is the house, resulting in some the garage being a complete loss, and there was some damage to the house. The owner at that time obtained a demolition permit to remove the remains of the garage, and that was completed in August of 2020. The current owner and today's applicant purchased this property since and has built a new garage without permits. This new garage build was observed by City of Winnipeg building inspectors in April of 2025 while on a site visit where they were conducting inspections for other work that was under permit, which was the renovation to that fire damaged house. In addition, it was to that they observed an air conditioning unit had been installed, but no permit had been obtained for that. As a result, the owner was directed to obtain the proper permits for both the garage and that air conditioner unit. Permit application was submitted in July of 2025. However, the application for the garage was deemed incomplete as it was missing details and documents that were required for review by the department. And a completed application was then received a few months later in September of 2025. However, at the time of preparing this report, the permit is not yet issued because there has not been payment by the applicant. The electrical permit for the garage is also not yet issued, also for lack of payment. And the permit for the air conditioner has not yet been applied for. I think I just repeated myself. Oh no, the garage needs 2 permits. That's why there's the build and the electrical. Yeah, so those both pertain to the garage. The electrical permit that would be required for the air conditioner has not yet been applied for, according to our records. So before the committee today Permit number 25-201227 AS. The fees owed are $249 for the permit, plus the fee in question of $443 for non-compliance. And the electrical permit for the garage, fees owed there are $76. The Winnipeg building bylaw and the Manitoba building code both state that a permit is required for construction and electrical work for any detached accessory structures intended to be used as a garage or and larger than 10 square meters or 108 square feet. The fee waiver committee reviewed the details of the application and rendered a decision that the non-compliance fees were correctly applied in accordance with council approved bylaws and fee structures. And the public service is requesting that the committee today deny the appeals and confirm the decision of the fee waiver committee.
Questions at all? Public service at this point in time? Yes.
One question, you mentioned earlier that the garage had a fire
Yes.
and it was part of the damage in air conditioning. So the air conditioner is new?
It's a new install, regardless if there was one there or
No,
not. There's a new install. I don't believe it was there before,
Okay.
but it was noticed by the inspector that it was a new installation.
All right, well, that's good.
Was there any type of demo permits that were required here?
No, the demo permit was taken out by the owner at the time.
Okay.
And the demolition of the garage was done under permit.
I see that the landscape of the entire property has changed significantly.
We've noticed that as well, but we're not, that's not before the committee today. We can take that up with the owner.
Okay. All right. Any other questions at this point in time?
And of course, I have
Yes,
one more question.
please.
The size of the garage, did it change?
To be honest, I'm sorry, I don't know the size of the
Okay.
garage. Yeah.
No more questions.
Okay, you can take on.
Okay, there is no one registered in support of or in opposition to this appeal, so just confirming no one in the gallery wishes to speak in support of or in opposition to this appeal. Okay. The committee wishes.
Is there anybody here is there information opportunity? No, not on these types?
No one is registered to.
At all?
Or like and this gentleman is for another appeal, so,
Yeah,
yeah.
okay, I guess I'm reading his submission.
Mhm.
He's got a written submission about, it looked like the installer of the AC told him he was not required to, I guess, take a permit out, so it seems.
Classic.
Yeah, and asking for a break, well, I'm assuming, how do we notify them if they're appealing? That we suggest they come in person, or they are suggested just to write something in?
We send them a notice which indicates that if they wish to submit their comments or register to speak to the appeal, they are to register via winnipeg.ca/public hearings.
Okay, so I guess we just gotta take his written submission. Okay, well, it's kind of harder to justify if he's not here in person if we have questions. So remind me again, okay, so there's obviously two sets of fees here. There's the non-compliance fee, right?
Yes.
And then there's the fee for the permit,
Right.
and all of it is all outstanding.
Yes, it's all outstanding, but the only fee under appeal is the non-compliance fee.
Okay. But you're stating he hasn't even
He
paid for
hasn't paid for
the,
the permits themselves
okay,
yet, and nor has he paid for I'm assuming he generalized. They haven't paid for the non-compliance fee either. So all of it is outstanding.
So for the garage permit, that would be $249,
Yes,
and then for the electrical is $76.
yes,
And because he did neither of them, there's a $443 charge non-compliance.
that's correct.
Okay, so, and all we're dealing right now with is the $443.
Yes.
Okay. So there.
well,
I read the submissions here. I understand that people, are new to building or renovations, but I would assume on Borbank, it's a investment, whether you're the occupier or the,
do we know if the person who's appealing is also the owner of the property and living there?
I don't know if they're living there, but they are the owner.
You don't know if they're selling it.
I don't know that. I don't know their intention.
Well, those would have been my questions to the person. Unfortunately, he's not here and not able to clarify anything, so I'm prepared to move motions. I move that the receipt of the public representation be concluded.
All in favor? Aye. Opposed?
I move that the
None.
appeal be denied and the decision of the Fee Waiver Committee of Planning, Property and Development Department be confirmed.
Favor?
Aye.
Aye. Opposed? Carried.
And I move that the appeal hearing be concluded.
All in favor? Aye. Opposed? Carried.
Please note the committee has made a final decision on this matter, which is not subject to further appeal.
Thank you.
Do
Sorry,
you wanna
just when I was making comment there at the end, on the investment, I was speaking about the property. This property assessed value is $421,000. So a 1% investment into permanent fees and whatnot is not unreasonable. Thank you. Okay, continue on,
Did you want to continue on?
please.
Okay, all right. So item 3 is an appeal under the Planning, Development and Building Fees Bylaw number 66 of 2016 at 28 Arpin Bay, work without permit. The process the committee will follow is the appellant will be heard first, followed by those in support of the appeal, those registered in opposition, those registered for information. The appellant may return to speak in rebuttal to comments made, but no new information is permitted. If you'd like a brief overview.
Please.
Thank you. Thank you for that. So in this one, I believe council or the clerk mentioned that there are 2 fees, one for an electrical permit or one for the building permit. So the 2 fees for at 28 Arpin Bay are $443 for work without permit under the electrical permit, the ER, and under the PR, it is $191 failing to correct defects within 30 days. So with respect to the work without permit under the electrical for $443 fee, on October 29th of 2025, City of Winnipeg Building Inspector was on site at 28 Arpin Bay for a scheduled inspection of other work that was under a separate permit. During that site visit, the inspector noted that the lower level or basement had been developed without permits. A bylaw violation notice was issued to the property owner, instructing them to obtain the proper or required permits. Those permits were applied for and obtained in the weeks that followed. The $443 work without permit fee is automatically added to the cost of the required permit as it was identified and imposed in accordance with the Winnipeg Building Bylaw and the Planning Development Building Fees and Charges Bylaw. With respect to the failing to correct defects within the 30 days fee of $191, excuse me, a defect was found during an inspection on October 27th, 2025. That defect needed to be corrected and a reinspection called for within 30 days. This is the responsibility of the contractor or the permit holder or the owner. On November 15th, a reminder email was sent to the contractor with respect to the defect requiring that correction and to call for reinspection. There was no contact to the department requesting either an inspection or a time extension. On November 30th, the 30-day window expired and the reinspection had not been called for, so therefore the non-compliance fee of $191 was imposed. Another defect was noted with respect to a framing inspection, which also required a reinspection, and a separate email was sent to the owner also on November 15th. The department did not apply a non-compliance fee for this other defect. We typically will just apply one non-compliance fee when there's multiple defects that are found, unless there's some extraordinary circumstances. So in the submission that we provided, there are 2 images below, which are copies of the warning emails that are auto sent. These ones being from November 15th, one to the contractor, one to the owner. And in them, they're very clear that of what it says, that it's the building permit regarding the framing. And the other one is the additional plumbing permit for the lower level. And it says if you have any questions, there's numbers to call on there. So we are asking that because the building bylaw clearly states that permit holders and property owners are responsible for compliance with the bylaw, the fee waiver committee reviewed the details of those applications And on December 19th, rendered a decision that the non-compliance fees were correctly applied in accordance with council approved bylaws and fee structures. So we are requesting that today's committee deny the appeal and confirm the decisions of the fee waiver committee.
Thank you. Questions?
I'm just a little confused. How many non-compliance fees are there? Just one or two? Was
There
there
are-
443 and a 191?
Yeah, there's 443 for work without permit, which was the development of the lower level without permits. And the 191 was after we've identified a defect. They did not call for a reinspection within 30 days, which they're required to do. Correct the defect and call us back.
Okay, that's the 191.
That's the 191.
And so since they have appealed, are they I can't tell from all this communication. Did it state that they have tried to attempt for someone to come in?
You have to ask the applicant. I don't. As currently right now, nothing's changed. There hasn't been another call.
There hasn't been a call to.
There
go
hasn't been another call for
Okay,
reinspection.
to inspect, okay, and you're not gonna go there unless, obviously, someone's gonna call. to do
Requirement is-
inspection, to set up an appointment, right? You're not gonna go there
Correct. Yes.
unannounced.
No.
Okay.
It's up to the permit holder
Yeah.
or owner to call the department when they're ready for inspection.
Okay. And the work without permit is for the basement?
Yes.
Okay. But you had mentioned that they had pulled a permit and it's been completed? Or is that for something else? Sorry, can you remind me again? So you said that they went in for a
Yeah,
site
they
inspection of October for an electrical, but they
Yes.
noticed the basement was developed and they were told to apply for a
Yes.
permit. So what happened with that permit? Did they apply?
They
for the-
applied, they obtained, and it's under inspection.
And it's
process.
under inspection all right now, okay.
What's that permit cost?
Under $200, I
For the
believe.
entire basement?
Yes.
And does that involve them, once a basement's developed, that they open up all walls and things like that?
There's a number of different ways to do it. They can, once for work without permit, once work has been done, if the work can't be viewed somehow, the owner has the opportunity to use a certification program, meaning they will hire an electrician or a plumber, whatever tradesperson, who can vouch that the work was done properly and provide the letter with a certificate stating that. There is the option that if we have to have the walls opened for inspection, that we could ask them to do that. We did not do that. in
They've
this
been
case.
compliant in that process?
So far, yes.
And do we have the appellant?
So there is an unrecognized name that's been admitted into the meeting. So there's someone in the meeting whose screen name is Shaz. Is this Sharon Skeet?
Yes, it is.
Oh,
Okay.
great. Okay. Is there any other questions for the public service at this time? Seeing none, we can move on.
Okay, so Sharon, there are two appeals here for the same address. One is for the work without permit and one is for failure to correct defects. Are you comfortable if the committee just considers both at the same time together?
Yes, but there has been some information given by, I don't know his name, but the gentleman in the white shirt with the patch on his arm, that is incorrect.
You'll have the opportunity to address the comments of the public service during your 5 minutes to speak to the matter. Would you like to turn your video on?
Unfortunately, my camera is broken. I'm sorry about that.
Okay, all right, you have up to 5 minutes for your presentation, whenever you're ready.
Okay, so I purchased this house and moved into it in June of 2025. At the time, I wanted to develop the basement. I called the city on numerous occasions. I wasn't getting the information that I needed or wanted. I physically went down to the city office. This was in August. I spoke to a lady there called Monica. She was very helpful. She actually explained the process to me. In that discussion, I disclosed that the basement was already partially finished. The previous owners had put up drywall and insulation on the outside walls of the basement. They also did do some outlets and switches. I filled out an application whilst I was there. when I came home, and I remembered I had another question thereafter, I called and I spoke to the city again. They told me that as the homeowner, if I am not doing the work, I am not eligible to pull the permits. The person doing the work has to pull the permits. However, I could pull the lower level development permit. I filled in and I did the lower level development permit and the plumbing and the electrical. The electrical was done by Sykes. When the basement development started, that is my putting a bedroom and a bathroom down there, the plumber had pulled his own permit. When the inspector had come for the rough-in inspection, it was noted that the outside walls were completed. So I said to the inspector at the time, they were not completed by me, that was the previous owner. He still issued the bylaw violation. I got on it straight away. Unfortunately, in your submission process, when you elect to join this meeting to speak, you guys say that you only allow one document. I had multiple documents to prove that I was on top of this, so I wasn't able to really submit anything because everything would not fit on one document. Regardless, I have numerous emails between myself and Sykes that actually indicate that the work was completed by November 12th. That was when they came and they fixed the work. Sykes had to pull the email because they were doing the electrical. They were the ones that did the certificate that the gentleman with the patch on his arm is referring to. And that was all completed. The plumber completed his part, and the people who were doing the actual contracting, the building, drywall, etc., they all finished their part. It came to probably about November 19th, 20th, 21st. I emailed the electrical company and I said, what is going on? Because that was a new permit that was pulled. So I said, I know that the plumbing permit has been received. I received the lower level development permit. All this work has been done. Please, what is going on? She said, I haven't heard anything, but sometimes the city take a while for the permits. So I was getting worried because obviously it was coming up for time that I had to book my inspection. On November 21st, you guys would probably have record that I put in all three, the plumbing, the electrical, and the lower level, because at that point I was in panic mode. I wanted the inspections done before the date that I was given. The city rejected all of them. I went back to Sykes Electrical, who did the electrical, who pulled the electrical permit. I wasn't getting anything from them. She just said, I haven't gotten the permit. I got on the phone to the city. I don't know if you guys keep records of calls, but there are numerous calls. I have everything here on my cell phone. When I phoned the city repeatedly from work, asking them, can you look into it? One day I did get a very helpful girl, and she looked into it and she realized, I think she said his name was Jamal or something like that. And she said something like, Jamal has your file. Your permit hasn't been issued. I said, how is that possible? The permit was applied for since like October, beginning of November, something like that. So she looked into it further. She said, no, the permit has not been issued yet. And that's what the holdup is. That's why all of your applications for inspection were rejected. So she did whatever she did in the background. She put me on hold. She came back. She said, we'll issue the permit today. I went back to Sykes. I said, this is what is going on. They will issue the permit today. Can you please let me know when you get it? Can you please let me know when they send you this certification thing, whatever it is you have to fill in, send it straight away. We'll double team it. I'll send applications, you send applications. That is for re-inspection.
Karen, did you need a minute or two more, or?
I'm almost there. I'm so sorry.
We'll give you
I'm
another
almost
minute
there.
here. Councillor Santos moves for another minute. All in favor? Aye. Opposed? Continue on, please.
Okay, at that time, Sykes filled in the certification. I was texting her, emailing her back and forth to make sure this was done. When she filled it in, I was told by the girl at the city, it's best that you call. It's probably quicker than you sending an email application. I was on the phone, I called. This was probably about November 24th at this point. I think that would have been a Monday. when I called on the Monday and I tried to get the re-inspection done, at that point, they told me there were no appointments left. It would have to be December 2nd. That's all they had left. So I said to her, well, that does not work, because I got the emails from the city that said that it has to be done by November 29th. So she said, well, I'm sorry, that's all that we have. Actually, it might have been the Tuesday or so. She said, I'm sorry, that's all that we have left. It was all within that week. I can't remember if the 29th was a Friday, but whatever. So we were left, when Sykes did actually get the re-inspection notices, they were given a date of December 2nd. That is the only reason that it went over.
Extension of time for 2 minutes. All in favor? Aye. Opposed? Carried. Please continue.
Sorry. That is why my re-inspections, which were all passed, were done on December 2nd. I was actively trying to mitigate this problem from November 21st, work with the city and work with Sykes to figure out what is going wrong. The holdup was that the permit was never issued from the city to begin with, and nobody at the city has been ever able to tell me why this electrical permit was not issued to begin with. So I feel I've done everything I did. I even paid these fines. I've done everything that I have had to do from my end, and I don't feel that this is really actually fair in the way that it has come about.
Okay. Any questions at all? Or sorry, I didn't catch your.
Sure.
What's your last name, ma'am?
Skeet.
Skeet. Thank you, for Miss Skeet. Any questions at all from the committee?
Okay, so I can understand regarding the basement. Although I haven't heard any comments about the failure to correct defects, or is that all together? Is that all?
The failure to correct defects was the bylaw violation. It was all together. The bylaw violation was the fact that the external walls had been drywalled and there had been some electrical. The failure to correct defects encompassed that, so I was told by the city. But there were also other things. I think the plumber had to put in a shower valve, which was done well before the deadline that I was given from the city. I have proof of all of this by text as to when I spoke to these people, set up the appointments, and when they came to the house, the work was completed in a timely fashion. Another defect was that they wanted me to use galvanized nails instead of regular construction nails when it came to the framing. The contractor had come back and he did that. The last defect, I think, was what we're referring to, the electrical having been put in the walls, which was all part of the bylaw violation. So by my understanding, everything, even though there was a bylaw violation that included the old stuff done by the previous owner, it still kind of all included all the defects that they found on the rough-in inspection.
So today you mentioned that you had a re-inspection done in December. Did that?
Yes, I'm sorry to interrupt. Yes, the re-inspection was done December 2nd and everything passed. Okay. The only reason that re-inspection was done December 2nd is by the time I finished grappling with the city to get the electrical permit issued, and Sykes had submitted the certification that needed to be submitted, all that was left for appointments was December 2nd. When I spoke to the girl on the phone, she even said to me, well, I'm so sorry, but that's all we have left now. So I said to her, well, how is this going to impact me? I said, this all has been done. The only reason this is late is because the city did not issue the electrical permit. It's my chasing of this that figured this out. So then she said, well, maybe you can just explain to them, because if you have emails and stuff like that, and obviously you've been calling us, I spoke to several people, some of them the same people, when I called into the city. That's how often I call the city to get this whole thing fixed, sorted in a timely fashion. But I've still got these standing fees that have been paid actually, because apparently I went past my 30-day when technically, no, I didn't. Everything was fixed. Everything was done. The permit was finally issued. There was just no appointment room left.
So Sharon, it looks like, I'm just looking at these submissions here in the exhibits. October 27th for the building permit and October 27th for the plumbing. So the electrical was not received at the same time for whatever reason. We can get some clarity from the public service on what happened there for the issuance of it. You did have a contact, a housing inspector, Kelvin Haywood. You familiar with that name?
Okay, the date that you're referring to, October 27th, that was the date that Calvin Haywood came. He was the building inspector that issued the bylaw violation. Prior to October 27th, all of the permits had already been issued for the work, except for the electrical permit, which was applied for afterwards by Sykes with regard to the bylaw violation that Calvin Haywood had identified.
Okay. And then in that notice that you received, there is an extension request form. Did you complete that at all?
Which notice are you referring to?
It's in regards to deficiencies outstanding, mentions your permit, mandatory re-inspection of deficiencies. It's under the exhibits pages. I don't have the page number here, but in the exhibits listed in your appeal. My question is, we won't be specific to what this email here is, but did you ever ask for an extension of time?
When I was talking to the girl on the phone, I asked if that was necessary. We were in the midst, though, of trying to figure out what happened to the permit, getting the permit issued, getting the certification to the Sykes Electrical, then back to the city so that I could get an appointment time. So at the time, I will hold my hands up. I'll admit I did not put in and ask for an extension because when I had initially spoken to the city and when I was speaking to the city to get everything done, there was appointment space.
Okay.
And then when we finally got the certification back to the city and the certification was passed by the city, then the only appointment space left was December 2nd. So at the time, I was not advised by the city, maybe put in an extension now or anything like that. What the girl actually told me, which I said to you before, was you can try to talk to them because obviously the work was done and you have all the emails and texts and everything like that. We've spoken to you several times, so they should be able to see that and see that you actually tried to get your appointment done and get the re-inspection in a timely fashion. So no, I did not go ahead and put in the extension request.
Okay. And is all the work done at your home now?
Yes, the inspector came back on December 2nd. It's just basically finishing that needs to be done. He passed it. He said everything looked good. So basically now we're just at the stage where it's just the small bits of finishing that you need to do.
Did you incur any other costs having to change anything that was done by the previous owner?
What do you mean?
So you're not the original owner?
No.
You explained to the committee that drywalling and electrical and whatnot was done, and that was...
Oh, yes, I did incur costs because to get this whole thing rectified, this certification done with Sykes Electrical, obviously I had to pay them to do it. I had to pay them to come in and look. I had to pay them to rectify whatever they had found, which truthfully, they said to me, I mean, they reamed the whole house. And they said this has all been done correctly. But there was just one little area where one plug had not been grounded, and they fixed that. But in doing all of that, that still cost me, I think, $500-600. On top of that, these fees.
Okay. Okay, we'll ask a couple follow-up questions here of the department, just in regards to timing around that issuance of the electrical permit, because it sounds like if that was not potentially delayed, like you're saying, that you would have met your deadline, so that's important as well. Thank you for that information. You'll have an opportunity to rebut anything that you hear before we vote on this matter, all right?
Thank you.
Okay, hold tight there.
Okay, so there is no one else registered to speak to this appeal. Just confirming that no one in the gallery is looking to speak in support of or in opposition to the appeal. Okay, if there are questions for the public service?
Yeah, please, Councillor Dobson.
Okay, the 443 is for the lower level electrical, that's automatic, right? You go in there and you see that there was no permit pulled for that, regardless if it was done 10 years ago, 30 years ago, it doesn't matter. There was no permit pulled, so that's an automatic charge, correct?
Correct.
Okay. And I understand the only reason you saw it is because you were in there doing inspections for permits they did pull.
That's correct.
All right, so to me, I'm just determining that they want to be compliant. They pulled permits and then the city found something that had to be properly inspected. And a permit pulled for the lower level. Okay, now for the failure to correct defects in 30 days, that means a failure to do an inspection, correct? Because it could have been fixed, but if we didn't inspect it, then we considered it not correct.
Yes, that's correct.
All right.
Absolutely.
So can you just clarify the timing on the permit if you have that?
I'm gonna defer. I have Gord Chuby is the chief building inspector, and he's online right now, and he's better suited to speak to that.
Thanks. Gord?
Gord, we've just asked you to unmute yourself.
Can you hear me?
Yep, that was good. Thank you.
Oh, sorry,
Can you give the
apologize.
committee some clarification on the timing around this electrical permit?
The first electrical permit for the wiring of the basement was obtained. It was applied for on October 14th, 2025, and it got issued October 21st, 2025 to the homeowner. However, because the electrical work was already covered, they cannot, that can't happen. So you have to have electrical contractor unless they want to open the walls. And obviously we didn't want them to open the walls. So that's why she hired Glenn Sykes Electrical to obtain the second electrical permit. That permit was applied for on November 10th, 2025. And it got issued on November 24th, 2025.
And would the permitting department be aware of the timeline that this applicant was under to be compliant for an inspection?
If they looked into it, but typically not. The BVN was issued and the comply by date was December 1st. It appears that looking at the inspection schedules, this got scheduled for an inspection on December 2nd. So a day after the fee would have been applied for the, what was $191. I'm just gonna double check that.
Yes.
Yes, $191. So just reviewing the file right now, that can be waived in my opinion, because they did request an inspection before that date and our system should have caught that.
Thank you.
So that fee should be waived, in my opinion.
Okay, we'll consider that. Thank you. Any other questions here? All right.
And that's with respect to the work without a permit.
No, that's the
No.
correct
Failure
defense.
to correct defect within 30 days.
Okay.
All right. I don't have any other questions. Any other questions from the committee? No, seeing none at this time. Thank you. Any other questions from Mr. Happychuck? Seeing none at this time. Okay, and then we'll go back to the appellant, Madam Clerk.
Okay, Sharon, we've just asked you to unmute your microphone and you have up to 5 minutes to rebut any comments you heard, but no new information is permitted.
Keeping in mind, Sharon, before you get started there, that the committee just received information that the appeal for your failure to correct defects would be suggested. It's not concurred in by the public service, but suggested that that be waived. So keep in mind that the committee's received that information. You don't technically need to speak to that, but please go ahead.
Okay, because there are two different fees here in question, I just want to be clear as to what is going on. Now, to address what Mr. Chuby said, what he said is correct. However, there is still a fee for $443 that was paid by Sykes Electrical. The confusion lies here with me and these fees. I received an email from a Samantha Madu after I had submitted a fee appeal for $443. When I got her response came back after I had sent in my appeal. She sent me a response on November 21st, and she said, the work without permit fee has been canceled, therefore a hearing is not necessary. That was November 21st. That was Samantha Madu. I went back to her and I thought to myself, okay, can you clarify? Are you saying that you're waiving the $443 fee? She said, yes, you do not have to pay the fee. Sykes, there was a little bit of overlap there. Sykes had already went ahead and Sykes paid the fee because, as I said, I was trying to be compliant with everything. So when I had sent the fee appeal in again, I wanted the $443 back. I was actually asking the city, can you please refund Sykes their $443? Because I got this email from Samantha Madu stating that that fee was waived. So when Mr. Chuby says they're willing to waive the fee for $191 simply for timing, I also would like the fee for $443 waived because I was told to begin with that fee was waived on my initial appeal for that. So I can't understand how these fees are still or how that fee in particular is still standing when I have an email from the city saying they waived it.
All right. If those are your comments, I'll just let you know that it's not up to Mr. Chuby to waive any of these fees. He just had made a recommendation to the committee, so it's the committee's decision on both item 3 and 4 regarding your appeals here today. So with that, thank you very much. Any questions at all? Skeen? No? Okay. All right. Thank you. Madam Clerk, are we able to get clarification on this waiving of the work without permit fee from the public service at this point in time? Or are we too late in that?
You can, but she should have the opportunity to rebut those comments.
All right. Is the committee interested in?
Yes.
Yes? Okay. Mr. Happycheck.
I'm getting a message from Chief Chuby that the lower level was developed previously without permits, so therefore, in our opinion, the fee does apply there. I would have to do some digging on the claim by the appellant that communications came from Ms. Madu regarding a waiver of that. So if the committee can give me a few minutes to do that, I can
Sure.
track that down.
Sure.
I'm prepared if the committee is interested in.
Dealing with that before?
I can deal with both items if somebody wants to take the chair.
Yeah, because getting new information, she needs to come back.
Have we introduced any new information? I don't believe we
We're
have.
asking him for clarification.
Yeah, I'm okay with not receiving any more information. I can move here if you want. That's fine. Councilors, Dobson, do you want to take the chair?
Okay.
All right. I'll move that receipt of public representations be concluded in regards to item number 3.
All those in favor?
Aye.
Aye.
Against? Carried.
I'll move that the appeal be allowed and that the decision of the fee waiver committee and of the planning, property and development department be canceled.
Okay. Are you looking for a full refund of there's $443 in fees? Are you looking to refund that from 443 to zero? Okay.
All those in favor?
Aye.
Aye.
Opposed, carried. Sorry, my bad. And so we'll have it. I'll move that the appeal hearing be concluded.
All those in favor?
Aye.
Aye.
Opposed? Carried.
Please note, the committee has made a final decision on this matter, which is not subject to further appeal.
regards to item number 4, Councillor Dobson, I'll move that the receipt of public representation be concluded.
All those in favor?
Aye.
Aye.
Opposed? Carried.
I'll move that the appeal be allowed and decision of the fee waiver committee of the Planning, Property and Development Department be canceled in its entirety to the amount of 0.
All those in favor?
Aye.
Aye. Opposed? Carried.
And I'll move that the appeal hearing be concluded.
All those in favor?
Aye.
Aye. Opposed? Carried.
Please note that the committee has made a final decision on this matter, which is not subject to further appeal.
So if Ms. Skeen is still listening, your fees will be refunded. Thank you very much. We'll move on. Thank you, Councillor Dobson, for taking the chair. I'll take it back. Item number 5 is an appeal. I'll have the clerk introduce.
Item 5 is an appeal under the City of Winnipeg Building Bylaw number 4555 of 87 at 456 Ross Avenue. The process the committee will follow is the appellant will be heard first, followed by those in support of the appeal, those registered in opposition, and those registered for information. The appellant may return to speak in rebuttal to comments made. However, no new information is permitted. So if you'd like a brief overview from the public service.
Please.
Thank you. Okay, this is in respect to 456 Ross Avenue. It was the scene of a fire April 7th, 2023. Caused significant damage to the primary structure, which necessitated the fire paramedic service to conduct an emergency demolition at the time of their response on scene. WFPS then issued the owners a notice of immediate action. An NOIA letter outlines why the fire department needed to conduct that emergency demolition. As that emergency demolition only collapsed the structure into a rubble pile, that left the property owner then responsible to complete the demolition and clean up under appropriate permits. The rubble pile was removed, however, in the weeks that followed the fire. However, no demolition permit was ever obtained to perform that cleanup. And the lack of a demolition permit results in no records of the demolition ever having been completed correctly, which includes no records that water or sewer or other utilities were terminated correctly. The department worked with the owners from the time of fire to encourage their compliance, and as the owner had included in their appeal submission, they did undertake to clean that rubble up quickly following the fire. However, because they did so without permits and in a manner that cannot be verified as proper, that causes an area of concern with regard to the termination or abandonment, is the language of water and sewer connections. So the department reviewed records with appropriate staff at the Water Waste Department, who confirmed they don't have records supporting a proper abandonment or cutoff having been done. January 16th of this year, email is copied on our submission there from Jeff Anderson, who's a technologist in water and waste, sending it to our department, advising that they have had no involved contact from the owner pertaining to that location, and they're not aware of any pending demolition permit applications because demolition permit applications do flow through Water and Waste Department for their review. And they have not seen one come through where water sewer blocking deposits would get applied to that abandonment of service of the servicing. He closes with saying the Water Waste Department has no record of abandonment or cutoffs completed under the required services permit for the above noted location. So when water and sewer lines are not capped correctly, there could be ramifications for other properties in the area, including issues on water supply, on water quality, or environmental concerns from wastewater seepage. The department issued a compliance order to the current owner on December 30th, 2025 for them to obtain the proper permits and have the matter dealt with by licensed contractors. Compliance order was issued in compliance with City Winnipeg bylaws, and we would ask that this order be confirmed in its entirety. A copy of the order, I believe, has been appended to your messages. We also supplied some photographs of the rubble pile post-fire there, and since then, rubble was removed. The piles that you see in that photograph were to be used for fill to level off the site. And most recently on January 15th, the site now is got trailers and apparently dogs chained on site, which our staff found a month ago. So the compliance order carries a fee of $1,461. That is the total of 2 administrative order fees and the administration fee for registering a caveat on file. That was issued to the orders, which is a numbered company here in the city. Or just outside the city, sorry.
Thank you. Questions?
Okay, so the compliance order that's being issued is to deal with the proper abandonment
Of the
or
water
cutoff
sewer,
of the water sewer.
correct?
Okay. However, the owners have cleaned up the rubble pile, but they cleaned up the rubble pile without a permit.
That is correct.
Who notified, so you're saying Winnipeg Fire Paramedics had notified the owner that there was an emergency demo. Does the Winnipeg Fire Paramedics let the owners know that they are responsible for completing the demo?
Yes,
There
that
should
would
be
have,
some kind of.
it would have been in there for them to contact planning property development to obtain the proper permits for the completion.
Okay, for the completion.
And then our staff would have gotten involved
Okay.
as well.
So during that time, has your office been involved with the demo site, like the demolition, like that where you're talking about, like if, like the Winnipeg Fire Paramedics would have told the owner to contact PP&D?
Right.
Okay, so did that happen at all or did not happen at all? When did your office get involved?
Our office was involved following the fire. Yeah, so in April of 2023.
Okay.
That's where
When was the rubber
that's
pile
where-
removed? Do you know?
in the months that followed after it warmed up that summer.
Thank you.
One question, so in 2023, I think that's when it was, if you were to try to get a demolition permit, what are the requirements for getting a demolition permit?
You'd have to hire a licensed demolition contractor
And,
and go through the process.
okay, but are you required to have a building permit after that as part of it? Or a development permit?
Because this was done under emergency, we by then we would have had the ability to waive that requirement without bringing it before this committee, as was previous. Those changes occurred in earlier in 2023 or late 22. My apologies, my memory is failing in that regard, but they may not have been required to have a rebuild permit
Okay,
in place,
all right.
a redevelopment, yeah.
Do we have, I guess the appellant here? Okay.
What activities taking place on the property upon last inspection?
There were trailers parked, like small trailers, utility trailers, and some dog houses with dogs chained to them. Is what we found.
Any other questions? Clerk, we can move on.
So the appellant is here with us in person today, Byron Gryba.
Yes.
If you'd like to have a seat, you have up to 5 minutes for your presentation.
Thank you. Excuse me.
So, I guess I should just ask. I wasn't really sure how this appeal process worked, and so I was going back and forth with the lady, and she just said, "We'll send a letter." And so I sent a letter, and then she sent the letter back saying that I needed to register. So that's what I did. I had a deadline to register. There was never any sort of information about providing evidence or whatever. I submitted my registration on the Friday morning, and because the deadline was noon, I submitted it around 8 or 9 o'clock in the morning that I'm going to be here. And then about 2 o'clock, I got another email. I think it was an email just saying, if you want to submit evidence, do it the deadline is 2 hours ago. And you can bring a USB stick. So I brought a USB stick kind of with the evidence just because that was really the only thing that seemed to be in compliance with the information I was given. And so there's some documents and stuff on there, but do I just plug it into the laptop?
Yeah, absolutely.
Send it to me electronically as well.
Sure.
Other side.
Other side.
Okay.
Select which document you'd like.
Okay.
We'll take a brief 1 minute or 2 minute break, and then we'll come back with to hear from the appellants.
Essentially,
It's okay. Item number 5. Thank you. Welcome back to Standing Policy Committee on Property and Development for this 9th day of February 2026. We are on our final item today, and I believe we are going to be hearing from the appellants.
Go ahead.
Whenever you're ready, please. You have 5 minutes.
okay, thank you. So just a brief rundown of the sort of transpiring of events. A little bit more detail than was provided. There was a fire at 456 Ross. It was actually 2 fires. Initially, there was one in late March. I had received a letter instructing that a permit would be required if demolition is chosen, and a permit with engineering assessment if repair or rebuild is chosen. The fire then referenced earlier by this gentleman was the second fire at Ross on April 7th. I received a registered letter advising Ross was demolished due to the second fire and structural safety concerns. So then it was very clear the building had been demolished. There was a fenced rubble pile with scavengers and children rummaging through the debris shortly after. And so I undertook to have that rubble removed, including the stone foundation, and the hole was filled and leveled. So that was completed, actually, I believe May 5th was a Friday. It was completed on a Friday. We just got in there, got it done, and that's what I had photos of the removal of the rubble and the foundation. About a month later, I think it was in June or late June, I was contacted by a bylaw enforcement officer by the name of Ray Rockwell that the demolition permit was required. I explained that the city already demolished the building. Ray acknowledged that he knew the building was already demolished, but a permit was still necessary, and the application would be fast-tracked since demolition had already occurred. Ray, was a couple of weeks later, he emailed me the instructions and the forms to submit the permit application, and I went ahead and submitted the application per his instructions by his email. Permit office rejected the application, saying a licensed demolition contractor had to submit the application. I called the permit office to explain the demolition had been completed and that no further work was required. Permit office indicated that the bylaw officer had a process to take care of this type of situation. I spoke to Ray to explain that the permit office told me that a licensed contractor was required. Ray had no idea, this is the bylaw enforcement officer, that this was required, but he would look into it, get back to me. He later emailed me with the new instructions to contact a licensed demolition contractor. I undertook and contacted several licensed contractors. I was laughed at and sworn at for wasting their time, having them check out a demolition project that didn't require any work. I spoke to the permit office again to explain my dilemma and was told that bylaw officer had a process to handle this. I called Ray, explained the dilemma and instructions in the permit office, and he would have a process to be able to take care of this type of situation. I told him that since he did not know about the requirement for having a licensed contractor, it was probably a new process that he was unaware of, but that the permit office said he would be able to satisfy the permit requirements. I told Ray, contact me if anything further is required. Next, I get a couple $1,000s of fines for not obtaining a demolition permit. I appealed the fines on the basis that I had not done the demolition, but in good faith, I followed Ray's instructions only to be denied the permit. I also explained the chronology of events that I detailed above. November 2024, the appeal was ruled in my favor, fines were canceled, appeal fee was reimbursed. I thought that this was vindication that I'd done all was required in the situation since the demolition occurred without my involvement, and the appeal specifically said, that's essentially said that there was no reason that a permit was required. That was the appeal that I had done on the fines. So in my mind, I've appealed it. I've got a ruling from the Winnipeg Parking Authority, notice of adjudication that no permit is required. Fines are waived or quashed and reimbursed my appeal fee. There was a follow-up email with Ray and a permit support specialist because they said, well, we still need to get this closed out. And so the final email from Ray in November of 2024 indicated that you will be contacted by the permit office to inform you how to move forward. So that was the last contact I had with Ray in November 2024.
Did you need some more time?
Just
Any extension moved by committee here?
2 minutes.
2 minutes moved by Councillor Santos. All in favor, aye. Opposed? Oh, please go ahead.
thank you. December 2025, I received a letter indicating the demolition permit was required and almost $1,500 of administration fees that was previously referenced have been assessed due to delinquency in obtaining the demolition permit. This letter now detailed that the building had been reduced to a pile of rubble by the fire department rather than indicating it had been demolished as previously indicated. I contacted Ray to ask why this had arisen again, as I thought it had been settled with the appeal of the fine over over a year ago, sorry. Ray said that I needed to get a demolition permit. I reminded him that I had tried to get a demolition permit. I had tried to get a licensed demolition contractor to get a permit for the demolition that had been done by the fire department, but was unable. He said that my situation was a common occurrence and as such, there was now a new permit process in place for me to obtain the permit. I contacted the permit office. I spoke with Mike, you can get his last name, and he said my situation was not a common occurrence at all, exactly the opposite, and knew nothing of a new process. He said that a licensed demolition contractor had to obtain the permit, but that in this situation, Ray would have a process to facilitate or obtain the demolition permit, which is exactly the same information I had been given when I initially started the process. I received a call from the permit office, Tony, a day or two later, informing me the information that Mike had provided only a day or two previous was incorrect. They now said Ray would not have a process to facilitate the permit and that I needed to contact a licensed demolition contractor to obtain a demolition permit. And then I appealed the order. I have tried and no one seems to be able to tell me what I'm supposed to do after the fact. The licensed demolition contractors that I have contacted, like I said, they said, well, we can't take liability for it because that's what the permit said. The permit office said I was needing to get a demolition contractor to take liability. And I said, well, I got photos where we did it. But anyways, so I appealed it based on the dilemma that I don't know what to do. And I want to get the permit. I want to close things out. No one seems to be able to give me the direction on how I do it. And the biggest thing was this fine. And so I guess my next avenue is small claims courts. I don't know.
Okay. Questions all from the committee at this point in time?
Okay, so there were comments being made by the public administration that there was no proper abandonment or cutoff of the water sewer. And that is where the compliance order is being tacked on to.
So
Could you make some comments and answer that?
sure. Actually, that was kind of one of my questions right from the start. Why do I need a demolition permit? I was told it was more of an administration thing, and I thought, fine, pay whatever $100, $500 and get it. And no one mentioned that, but having said that, I did speak with Water and Waste, and they said, well, we disconnected it because of the fire department. So they had a hole across the street. They totally disconnected the water supply. And so I have been in contact with the water department. Because the funny thing is, they the reason I found that out is because I was still getting charged for water and sewer, water bills.
Yeah.
And I said, well, you cut it off. And they went through the system, you know, I'm just on hold here. And, oh yeah, you're right. We cut it off on April 7th, the day of the fire. So somehow the water department knew to cut it off. I'm assuming that whoever demolished the building
That would make sense.
had it cut off.
Do you have documentation that shows that Water and Waste cut it off on April 7th?
I don't. That was just communicated to me when I called the water department. I called them not because of that. I called them because I'm getting water bills after the fire.
But now you're no longer getting water bills.
No, I'm not getting water bills, thankfully. I am still getting requests to have a fire inspection of the building.
We happen to have anyone with Winnipeg Fire Paramedic Service who could answer their process and when they demo, if they order a water shutoff?
That's a good question. As chair of community services, I don't.
I don't have anybody handy. I mean, there are people that we can ask, but they're.
That'd be helpful.
Okay.
Sorry, Mr. Chair, are you asking me to do that right now?
Well, information that was given to you was that there was no information about.
The information, I only contacted Water and Waste. We didn't contact Fire again.
Right, but Water and Waste should be talking to Fire when a demo is being done. I would assume that Fire Paramedic Services has a process when they're gonna pull a building down on what needs to be done or double checked.
They do, and I might be missing a few things here, but they've got a list of contractors on standby that they would need.
Sure. So I'm
bring
sure
them in. So
Director
perhaps.
or Chief Schmidt could get somebody to answer that question for us because it's unfortunate that the department is sent here today with no information from Water and Waste, whether or not there's a shut off process or what the case is. We need the information committee. Either that or we're just left to take the applicant's word for it or the department's information that they were given by Water and Waste.
Mr. Chair, if it pleases the committee, if you choose to put this over, we can return back and get all the departments together, get a proper answer. The applicant is saying that Water and Waste is telling him that they did do the cutoff, which is sort of in opposition to what Water and Waste was telling me. So I personally would like some clarity on that. But if we can get that done and to the satisfaction that is required, then we can notify the clerk whether or not there actually needs to be another hearing. Okay. If that's amenable to people.
So does this decision was made by the department?
Well, the department issued the order. Our department issued the order on December 30th, so just over a month ago. And the recipient of the order has appealed it to this committee, which is his right. And so we can just put any enforcement into abeyance of this order right now, and we can come back with a better answer.
Well, it is very important to find out if the water department disconnected everything, because that would pretty well solve quite a bit.
However, the issue before us is the permit for demo, which the public service is stating that it's.
So if, and don't take this the wrong way, sir, if your information is accurate and Water and Waste has done a disconnection and tapped it at the time of the fire or whenever that was, and we can verify that, then there's no need for this order.
Yeah, the order can be canceled. Because that's what I was hearing. The whole point of the order was the fact that the water was not capped.
So part of the building permit, it would be to cap those two lines.
Demo.
Yes, the demo permit
Yeah, pardon me, the demo permit would be
would to terminate all utilities.
Okay.
So in this instance or any other instance, when a demo has been done, or whatever, reduced to rubble,
Right.
Whatever terminology we want to use now, is there a requirement for a demo permit to remove the
There
files?
is, and normally we would look to enforce that. In this case, I think that we would, depending on what ultimately comes forward here, I think we would look to put this one to bed, so to speak. But under normal circumstances, when fire drops a building, and services are capped and everything else, there's still a rubble pile. The owner is responsible to get a demo permit to complete the rubble pile removal. And the reason for that is that demo pile may have asbestos containing materials in it, and it needs to be properly dispensed of and stored.
And so what we're seeing today is the applicant had removed the rubble pile back in May of 2023 under whatever accord that you have done.
And so I'm guilty of doing it. I thought the building was demolished. It was a liability, kids. I got 5 kids. When I see them, I just went in there, clean that up right now, and that's all I did. And rubble and everything. I pictured not rubble foundation. It had those old type of foundation. It wasn't a concrete foundation. I've got pictures that we removed everything and filled the hole. Just as a comment to the existing, I drove by, that's the neighbors who have sort of fenced off the area and have some trailers. That's not me. So it's the neighbors have sort of, and it's not like we're doing anything with it. They're preventing me from getting vegetation orders because they're cutting the grass and having their dogs on it. So if that's a violation in some way, then I guess I can ask them to get off it, but it just seems like they're using it in a residential fashion.
That's between neighbors. But I appreciate the explanation. Okay.
So I did remove the demolished building.
Without a demolition.
Without a
That is correct. That is
And
correct.
then someone followed up with you afterwards in June that you were required, in 2023, that you
Right.
were required to do a demo.
A bylaw enforcement officer, and I
At any point in time, did they ever talk to you about terminating the abandonment of the water and sewer during that permitting time?
not specifically
So this
because
is new information, like hearing about the.
yeah,
abandonment
this
of
seems to
water?
be the focus of what is required, and it was definitely never the focus of why I needed it. It was more that it follows our process and we have to
Right,
do it.
right.
And I thought, well, I understand everyone's got a process. It's going to cost me, I didn't know how many money, hundreds of dollars, but I thought,
Okay.
let's follow the process. But then I was told, once I did follow the instructions that I was given, then the permit said, no, you can't do it. You have to get and the bylaw enforcement officer didn't know anything about that. And so then that's where I came up against this wall of having to hire a licensed demolition contractor to
And
apply.
nobody would do it.
Because there's no work to be done.
There was no work to be done. So you came and appealed, and then at that time, the appeal was supported.
Right, I appealed the fines that I was getting.
Yeah.
Those would have been penalty notices issued
Penalty notices.
for failing to obtain a permit.
Okay,
And then he would have taken those appeals to the parking authority.
That is correct.
Those would be issued under the Manitoba, the Municipal Bylaw Enforcement Act. They would not have come to this committee. That's not where the appeal came. The appeal, those are tickets written, and then they go over to, under the auspices of the screening office at the parking authority.
So demo has to do with parking authority?
All tickets or penalty notices, regardless of who issues them, fall under the Municipal Bylaw Enforcement Act.
Right.
And the appeal mechanism is through the screening officers at the parking authority.
I had no idea.
I am now even more confused.
Sounds logical.
Oh.
I think that we can, any other questions for our appellant today? Okay, we'll let you either hang around and wait to rebut, or you can take off, whatever you'd like to do, but that'll do it for questions at this point in time. Thank you. Are there any questions for the public service at this point in time?
Okay, so obviously with the information we've heard about
Did you want
the
to-
water, with the water abandonment cutoff, it seemed to say that he has confirmed that when he contacted them,
Yes.
because he was getting water bills and now he's no longer getting water bills for the last couple of years. So if this has to do with the abandonment, what do you suggest? Do we suggest laying this over until the next appeal, and then you find out your homework, you find out confirmation, but you still have to come back here? Would you be then telling us at that time that if you got confirmation, you have the jurisdiction to say we can cancel the order? Or do you have to still come back to this committee? How does that
Well, if we
work?
cancel the order, then no, there'd be nothing for the committee to rule
Had
on.
this situation before and it does have to come to committee.
Like if we laid this over,
It's withdrawn appeal, like as the order was canceled, the appeal was withdrawn. An acknowledgement.
okay, so if there's some kind of acknowledgement, then you would notify the appellant.
Yes.
And then the appellant can withdraw their appeal, and then you would delete basically the order,
Yes.
and then it would not come back here. Okay, so if I can lay this over, that's enough.
That would give us enough time
Okay.
to do additional research.
And check with Waterworks to see if they.
Yeah.
Okay.
That makes sense. You don't want it to come back at all? Well, I mean, if they do their homework, then it doesn't come back. It just notifies the owner and it doesn't come back. They cancel it and he just
Yeah, there's more issues
withdraws
than
his
that,
appeal.
though. That's my issue.
Mm.
Like hearing the process that the that the appellant went through is also.
So a little more background there
Sure.
is that would have been at the time when we moved from anyone can apply for a demolition permit, a homeowner, to moving it towards the licensed demolition contractors. That did occur in early 2023. Confusion probably clearly was in place with certain department staff, and that's probably on us for communicating it down the line. But I can confirm that is right around when we started that process of requiring a demolition contractor to pull demo permits. Yeah.
Okay.
Discussion for another day, but perhaps we need to revisit exactly what is required for cleaning up rubble piles as opposed to.
It is an active file that we are working on.
I mean, we can lay it over if that's the will of the committee. However, we see several issues like this where there are rubble piles on properties for months and months, if not years, and it looked like the appellant went to the means to clean them up in a timely manner.
Yes.
But
So-
at the end of the day, I would like to, and I mean, we can figure this out offline if there was. If there is a process for WFPS to follow, that includes turning off. water.
Contacting water and having
I
water
would
turned
be
off.
shocked if they don't contact water and hydro.
Well, they do. That much I can confirm, but to what extent
Mhm.
the emergency at some point, they may just turn a valve. And that's, but it doesn't mean that the sewer connections have been properly terminated. So it depends on the property. It depends on what area of the city. The older areas have much different infrastructure underground.
So then who would be responsible for capping it? Because I understand when you turn it off,
Well, so
who's
the
responsible?
demolition contractor is responsible under the
Capping.
permit,
Under
yes.
the permit for
Yes.
capping. Because that's different. I understand that is different. Capping is different than just turning it off.
Yes,
Because when you cap it, that means you're basically cutting the whole.
well, you're terminating it at
Terminating the line,
the
yeah.
city connections, right? So
Yeah, I totally understand that.
Yep.
Okay, and that, when you had followed up with water and waste, they had confirmed that the capping was not done.
that's what the information came back as.
Which also makes sense.
So while the line might have been, okay, so at capping and removing of I'm assuming when you cap it, do you cap it on the city Winnipeg side or on the property line side at the shut off valve?
That's a question for water and waste. I don't know those details,
Okay,
but demolition contractors know how to do that work. That's why they're.
So in your
they
past
get hired.
experience with these rubble piles that are remediated, does a demolition crew go in and clean up the mess?
Yes,
Even if the city has pulled down the structure?
yes. And part of that, and they do it under permit, and part of that permit would be to ensure that all utilities are capped properly or terminated properly.
Okay. So then this applicant is appealing the fee associated?
I think they're just appealing the order, the need for the order, is my
The
understanding.
demo.
The demo.
The demo, yeah, you'll get an opportunity to come back then.
The fee is not subject to the appeal. Okay. So the order,
The order.
the order is what is in question here today.
The order, okay, the order.
So the applicant never got a demo permit at all.
One was never issued. It sounds like he tried to and could not find a suitable, a company to take him on.
So the order would remain if we, what's the word I'm looking for here? If we denied the appeal, the order would remain and he would still have to get a demolition crew
Yes.
to go in.
Yes.
And now they're gonna be looking at a remediated property, so they would essentially now just be digging up to cap.
Verify it, but if we can do that through conversations with Water and Waste and verify that it's been done as is the appellant is suggesting, we'd like to explore that first before ordering someone to go dig up their front yard.
Is there a separate application to dig up? Like, is there a separate permit to dig up and cap?
No, so
There must be something, like Water and Waste.
the
is
demolition,
cap just-
demolition permits are issued by Property and Development,
Yeah.
by our department. Within that, there are processes that go out to Manitoba Hydro, Water, Waste, and other necessary departments that they do their review on their end. And so whatever that may entail, and then they send it back when it's cleared. So it's like a circulation in
Yeah.
the old style, right? So it gets circulated around, everybody signs off. Once we get the sign off back, we can issue the permit. But it's done electronically now.
So if we make a ruling on this here today and it's not capped, it will stay uncapped for however long until.
Until somebody goes in to build there.
Okay, so there's no way for us to not require a demo permit, but require the applicant or the appellant to get a permit to cap a line? Is there such thing?
No, it would just be the demolition permit itself. There isn't, unless Water and Waste has one that stands alone, but I don't believe that they do because they push all customers to our department to get that demolition permit.
Interesting. Great. No, it's not.
Okay, let's then with that information, I'll retract my unwillingness to lay over and let them get this sorted out. I would assume that the water, and this is just me assuming, so we shouldn't do that in this body, but I would assume that the line has not been capped and that the water has been in fact shut off. That's why he's no longer receiving any bills. Before we move to lay over the matter, do we want to hear from the appellant to rebut comments? Yeah, okay. Anything else for the public service? Okay, we'll invite the appellant to come back up, Madam Clerk.
Yeah, I may clarify for you that water billing is done through a meter.
Right.
Yeah.
So if there's no meter, there's
Yes.
no billing.
Yeah.
When I was holding up my hand, the gentlelady answered the question about the fine. I wanted to appeal, but she said I'm not allowed to appeal the I don't know if it's a fine or administration fee or something. That really was the crux of, even though I knew I couldn't do it, I thought, well, if this is the only option I have left to me, this is what I'm going to do. And sort of put myself at your mercy and ask if there's any way it can be reversed. I want to get whatever permits are needed to get this all closed. So if I can help it, then I will. No one's telling me how I can help it. They're telling me land on the moon, and I say I can't. Well, just do it because that's what has to be done. That's our process. And so that's the position I'm in. Is I'm just being told to do something that a licensed demolition contractor, the ones that I've contacted, just said, "Oh no, there's nothing to do. We don't want it." So if there's anything I can do, then I will. I wanted to get these fees removed. And if that's not possible, then like I said, the only option I have is a small claims situation. So I will go that route if I need to. As far as capping and shutting off, I am 90% sure it has been capped. The shut off was on my side of the street, on the building side of the street, and shut off for the water. They dug a hole on the other side of the street, where the actual water main is. And so I'm pretty sure they shut it off. At least that's the way that's really the way it appeared to me. I don't know if there's anything else, but like I said, if there's a way to satisfy it, showing photos and whatnot to show that I've done things properly, then I have those that I can provide. But right from the start, I wanted to try to cooperate. It just seemed that this was not working, and I understand it was a new process, so I have some grace there, because obviously new processes get things have to get worked out. But I do appreciate that you recognized I removed that rubble in good faith. I think just as not even that it applies to me, but I'll just throw it out there. I think there was 10 fires within a 3-block radius and 2-week period of my fire. And so there was rubble piles everywhere. And so besides wanting to get it done quickly, I was thinking, boy, everyone's going to need, if I get mine out first, I won't have this pile sitting forever while people are waiting. And so I own that building, which is just a few blocks from here. Not a great neighborhood. I owned it with family for 20 years. We bought it, we fixed it up, we housed low-income people. We had a very safe building in a very bad neighborhood. It ended this way. Thankfully, no one was hurt. And I didn't want a pile of rubble to change that history. So I appreciate you recognize that I did get out of there in good faith, not because I was trying to screw up a process here.
Mhm.
That's all.
But we still have the issue to deal with, is the capping or no capping. We were
Right.
just under the assumption it was capped at the time when the fire had occurred.
Yeah, as well as I was there with the crews removing the rubble, and they're saying, are you sure? And so, oh yeah, that's right. I had actually phoned water because the demolition guy, he was a retired demolition guy, but now he was just removing the rubble because, so he's saying, are you sure this has been done? That's right. I phoned specifically asking. Now, I don't know that I used the terminology. Has it been capped or shut off?
Or shut off or different.
There are differences.
I understand that now.
Would you be opposed to us laying this matter over?
No, like I said,
You're not facing any additional fines or penalties at this point in time. So it's just the order.
right. And so.
And there'd be no further enforcement on this order in the meantime?
No, we would put a pause on this until we get this
Okay, great.
all straighted out.
And then if someone can tell me
Yeah,
Yeah,
how to go about it, then I will go about it.
Yeah.
sure. Okay,
okay,
thank you very much.
thank you.
Anything else? No? Okay.
Okay, can I at least, do you want me to at least close the public representation and then move to layover?
If you close public representation, then if the public service does come back with any additional
Oh,
information,
then,
it's.
okay,
Yeah.
so then I'll just move layover.
Oh, really? They count as public representation?
The appellant should have the opportunity to rebut comments made by the public service. So if they're bringing new information for the committee's consideration that we didn't have at this hearing, public service or the representations should remain open.
Because the order could still be in fact,
Depends on what we find.
depends on what they find out. Okay, so I'll just lay over item number 5 to next month's meeting, which is, what's the date?
So there's the regular meeting on March 5th, and then there's the appeals meeting on March 16th.
Okay, so then it'll be
Let's-
March 16th, or do you want to deal
Let's
with
just
March
deal with
5th?
it. Yeah,
March
March
5th.
5th. It's fine.
March 5th, okay.
I'll be away, but I'll send someone in my place.
Okay,
So the appeal hearing be adjourned to the standing committee meeting on March 5th, 2026 at 9:30 a.m. in the council building.
And just this body will be able to hear that?
Yes, so as Councillor Wyatt was not at this hearing, he won't be able to participate in the hearing on March 5th.
all right, sounds good. I'll move that.
All in favor?
Aye.
Opposed? Carried. We'll hear this March 5th then.
Okay, I move consent agenda and adjournment at 11
Do you need
a.m.
to finish any formalities? No?
It's,
Okay,
yeah.
great. Consent adjournment moved by Councillor Santos. All in favor?
Aye.
Opposed? Carried. Thank you very much. We'll see you back for the regular meeting of Property and Standing Policy Committee on Property Planning and Development on March 5th.